Welcome to OnAir with Akin. I'm Jason Daniel, a partner in the Dallas office. I'm joined by Barbara Niederkofler, a partner in the New York office, and a special guest, William Wetmore, a partner in our San Francisco office. We're going to talk about the regulatory developments in March and a little bit in April. So starting with the Internet Advisors rule that was adopted in March. So what is this Internet Advisors rule that exists already, and how does it work? Well, the Internet Advisors is a carve-out that's been around for a while, and it's actually an exemption from an exemption. So how it works is there's actually a threshold that you have to meet in order to be able to register with the SEC, either an assets under management threshold, or you're registered with enough states in order to be permitted to be registered with the SEC. The Internet Advisors exemption allows you, if you are only operating through the internet, to have a carve out from the prohibition, an exemption from the prohibition to be able to register. So what that allows you to do is, so let's say you're providing services only through the internet, it makes it so you don't have to look at where every client is in order to determine the states you have to analyze. Instead, you're able to go directly to SEC registration. The SEC finalized the slight changes to the rules, but this is not one that we normally see all that much. So I wouldn't get all that excited about it. But the main thing is, if you're an internet advisor, you have to be an internet only advisor, and you have to be not doing, you cannot be engaging in phone calls, in-person meetings, or written correspondence. Also this month, the SEC adopted rules for climate disclosure for reporting public companies, which augurs that there will soon be rules adopted for investment advisors. That was proposed a while ago, and we discussed it on a previous podcast. Of course, that was immediately challenged when the rules were adopted.
Another challenge that came about in March is the National Association of Private Fund Managers, the Managed Funds Association, and the Alternative Investment Management Association filed suit in the U.S. District Court for the Northern District of Texas in Fort Worth, challenging the dealer definition rule adopted by the SEC on February 6th.
Now on to enforcement actions. And there's a recent case regarding 13D versus 13G. William, you want to tell us about that?
Absolutely. So this was an enforcement action brought on March 1st and settled against HG Vora Capital Management, which had purchased a position in Ryder Systems, the truck leasing company, and had acquired in 2021 a position of 5.6% as of the end of the year, and filed a Schedule 13G as a passive investor in February of 2022. Between that February of 2022 and April of 2022, HG Vora had gone to private equity firms and had tried to convince them to acquire Ryder. They had stayed on that 13G, and during that time had acquired up to 9.9% of the company. On April 26th, HG Vora, after the private equity firms did not express interest in acquiring Ryder, decided that they may want to make a bid themselves and started drafting a placeholder offer letter to acquire the company. The next day, they contacted outside counsel to discuss the potential offer. During that time, until May 12th, 2022, HG Vora acquired cash-settled swaps in Ryder. And then on May 13th, they delivered their offer letter to the company and filed a 13D, disclosing that they had made the offer for the company and were now an active investor. The SEC looked at this and said, well, when were you really an active investor? When did you need to switch from the passive form, the Schedule 13G, onto a Schedule 13D? So to just rewind and talk a little bit about 13D and G in general, a beneficial owner of securities of an issuer with a class of equity securities registered under Section 12 of the Exchange Act is required to file a statement of beneficial ownership on Schedule 13D within 5 business days of acquiring beneficial ownership of more than 5%. A 13D requires detailed disclosures, including about beneficial ownership, but also about the filer's plans and proposals that relate to the acquisition of securities of the issuer or extraordinary corporate transactions, and any agreements with respect to the securities, including swaps. A Schedule 13G, if you can make a certification that you're a passive investor and hold in the ordinary course as an institution, only requires disclosure on beneficial ownership and the identity of the filers. It doesn't include all of that disclosure about your plans. But if you develop an active intent, you're required to switch to a Schedule 13D and file within five business days of developing that intent. And there's also a cooling off period that's required when you develop that intent, that you can no longer acquire any additional beneficial ownership or vote your equity securities from the date you develop the active intent until 10 days after filing the Schedule 13D. That's typically referred to by practitioners as the cooling off period. The cooling off period wouldn't apply technically to swaps because swaps, cash settled swaps, don't represent beneficial ownership under 13D. However, the SEC in bringing this enforcement action somewhat applied a de facto cooling off period by saying that because the Schedule 13D wasn't filed within 10 days of the date that the SEC concluded active intent was developed, that HG Vora took advantage of their 13G position and not disclosing their plans and proposals to be able to buy the swaps at a lower price point, lower entry point. And this raises a question first, like what is the threshold for having to switch to a 13D? How developed do your plans need to be? Many practitioners would hesitate to want to file when they receive a draft of an offer letter, when that intent may not be fully developed, that the investor may be considering going active and making a proposal, but they may not have fully decided. Here, the SEC said at a minimum, it was when they decided to start drafting the offer letter and contacting outside counsel. But they also earlier had gone out and actively pursued private equity firms to acquire the company. So it raises questions about when exactly that point is. It's not entirely clear. Also, whether we should consider a de facto cooling off period for swaps and what advice investors should receive regarding acquiring swaps when they're in that gray area.
So it raises interesting points. You definitely have to slice it very thinly of exactly what's happening at what time in order to look back of when the trigger is. But a lot of times courts don't necessarily look at the trigger as when there's a potential plan. They're more likely to look at a proposal, but it does make it pretty tricky. And I think the key is that they took advantage of the information by entering into the swaps and having increasing an economic stake. But the words of the rule don't actually prohibit that. So it'll be a little challenging what to do with that going forward.
Exactly. And if they would have filed within 10 days of the time and the SEC said they were active and acquired swaps during that period, could the SEC really have claimed that there was any kind of violation? Because it's not technically a violation of the cooling off period. But if you file late and are acquiring a greater economic interest, then they would argue that, like you said, they were taking advantage of not making the activist disclosure.
And whether that was actually late is a little ambiguous.
For sure.
Another notable enforcement action is in relation to AI washing. The SEC brought and settled charges against two investment advisors on March 18th related to their statements regarding their purported use of artificial intelligence. The SEC found that the firms made false statements in public filings, social media, and on their websites claiming to use AI in investment processes when in fact these statements were untrue. In the action brought and settled against Global Predictions, Inc., the SEC also claimed that the advisor referenced the performance boost of the models to a mass audience, which was a violation of prohibitions in the marketing rule regarding the use of hypothetical performance. The SEC also spotlighted issues with the advisory contract, including the ability to unilaterally update without disclosing the changes to the contract, and an exculpation clause that purported to hold the advisor harmless for any claim or demand, regardless of the theory of liability, that, quote, could have misled retail clients into not exercising their non-waivable legal rights, end of quote. These enforcement actions, while they certainly have AI washing in the forefront, address other issues that the SEC staff have been looking at, including marketing rule, as well as the hedge or savings clause.
I guess we'd be remiss not to at least casually mention the recent electronic message retention case against Senvest that the SEC brought and settled. That happened in April, so it's not technically part of the March summary, but it raises some important issues because it's the first time that the SEC has gone after an investment advisor, the standalone investment advisor, with respect to books and records violations for electronic communications. Here, they did mention that there were electronic communications that related to advice, as opposed to on the broker-dealer ones where it could just be all communications. But there are also issues with the policies that seem to address all electronic communications anyway. But we'll talk about this more in depth in the April version that will come out in May. So now on to some recent judicial cases. There was William, I guess the Delaware Chancery Court is going to radically or could radically change what you can agree to settle proxy contests.
That's right. So as in many activist situations, when a full-blown proxy contest doesn't take place because there's a settlement between the company and the activist investor, in the settlement agreement, often there'll be governance agreements, concessions to the activist or agreements between the parties, as giving board seats or guaranteed committee representation. And this case, the Moelis case, calls into question the validity of many of those potential governance rights. So the court looked as to whether a shareholder agreement, provisions in a shareholder agreement, would unlawfully constrain the board's discretion to govern the company in violation of Delaware General Corporation Law, Section 141A. So in looking at these agreements, the threshold question that the court looked at was, is the contractual provision part of the company's internal governance arrangement? So once it was clear it's a board right or committee representation, or you can't remove the CEO. In this case, it was the founder and CEO, which the company could not remove the CEO without his consent. So pretty good deal. So that was clearly, regarding the internal governance. So if that's the case, there's a two-part inquiry. First part, is the provision part of a governance arrangement or just a commercial arrangement? So the court wanted to distinguish certain commercial arrangements, that certain rights that or restrictions on the company that were given for consideration, like, for instance, a credit agreement. If there were restricted covenants on the company due to the commercial arrangement for giving the credit, they did not consider that a restriction that would violate 141A. But some of these other clear governance provisions in like a stockholder agreement may be violative. So if they were considered a governance arrangement, they go on to part 2. Does the provision improperly restrict the board? So do the decisions invalidate constraints, expressly say the board cannot take a particular action or must take particular actions? And so this could create real issues for settling proxy contests. If activists can't gain these concessions due to stockholders agreements, and will have to either like put things in the charter or reduce the rights, such as instead of getting a designation right, maybe a nomination right, but then the company wouldn't be obligated to support in all respects and advocate for electing that director. There's some extent they could help, but not to the extent that they typically do in these kinds of agreements. So if these stockholder agreements, settlement agreements between activists and companies are increasingly challenged, we may see more full-blown proxy contests in the future.
And I guess the other way you could get around it is you could try to have a stockholder agreement, where stockholders agree to vote in favor of a particular candidate, but then you're creating group issues and Section 13, Section 16 issues that could arise in that context.
It's difficult to you could create a new class if the right is in the charter. That is separate, so that would be allowed. It wouldn't violate 141A. So if you have a special class that has certain rights to designate, like a preferred class that could designate, that would be carved out of this restriction.
And this is really also is a corporation law matter specifically. So for LLCs, this isn't an issue because the LLC statute everywhere says, except to the extent stated otherwise in the governing document. So there's always an override ability. So a non-corporate entity wouldn't have these same issues. So now turning to the Coinbase case, the SEC brought a case against the crypto exchange Coinbase for violating a number of things, including violating the obligation to register as a national securities exchange, to register as a broker-dealer. And the most interesting part, I think, was the SEC's claim against for staking. And the fact that the SEC was claiming that Coinbase needed to file a registration statement that was, in fact, this normal staking that goes on, especially through their exchange, would require a registered offering in order to permit that. That's a new change, and it seems like there was potential interest from the SEC for others that are trading through the staking mechanism. The court in the Southern District of New York denied the Coinbase's request for a motion to dismiss. That, of course, doesn't necessarily mean that everything has been proven, but from a legal position, the court is willing to entertain the staking as an unregistered offering concept. They did dismiss claims that operating a crypto wallet was effectively acting as an unregistered broker, but that's not a substantial win. The other parts of it turned on basically as long as one of their cryptocurrencies was deemed to be a security, then Coinbase would be viewed as an unregistered securities exchange, and then with the staking concepts. A number of those cryptocurrencies had a significant ownership by the founders, and had at least two of them had a concept where they would burn tokens in order to maintain the current price. So that was enough in the court's view, to view that as reliance on the efforts of others and to be a security under the Howey test.
while we're all recovering from March.
Yeah.
Unfortunately, there are several compliance dates to be thinking about.
So the first one is the shortening of the settlement cycle. That is rapidly approaching. On May 5th, the T+1 will become effective. What does that mean for registered investment advisors? And we talked about this in a previous podcast. The obligation of registered investment advisors is to affirm the transactions on the day, on the trade date, so that it may settle on a timely basis on the T+1 basis. So what does affirm mean? It means that it's clear where the securities are going to go, which account is going to go to, and final allocation of the trades. The SEC emphasized this rule in its SEC Speaks at the beginning of April, and there was a Division of Examinations risk alert that was published, and that emphasized first the fact the rule was coming, and also urged investment advisors and brokers to use electronic systems for affirmation in order to ensure that the books and records are created on the date of the trade. Now we'll go back and talk a little bit about, so we had these things that came through. What is the impact on fund documents? I think the big one really is people who are trading crypto, considering the new risk that occurs from the SEC's view of staking as an unregistered sale of securities. So if you're trading crypto, consider a risk factor change.
I would add to that, Jason, dusting off disclosure on AI, particularly in light of the A-washing enforcement actions we discussed earlier.
And I guess that can even boil down to, if you have risk factors that talk about AI, make sure that it doesn't say that you are using AI if you are not, in fact, using AI. If you may use it in the future, make sure that it is a may disclosure.
Yes. And conversely, if you are using it and are not disclosing it, you should be thinking about adding at least a risk factor.
So then finally, for approaching calendar dates, the end of the month means delivery of the brochure, ADV Part 2. It also means filing the Form PF if you're not a large hedge fund advisor. And it also means delivering audited financial statements. But remember, this is a leap year, so everything moves one day in advance. I guess that wraps it up for the March summary and April upcoming events podcast. So join us next month for the new regulatory minutes.
Thanks all for listening in.
On Air with Akin is presented by Akin and cannot be copied or rebroadcast without consent. The information provided is intended for a general audience and is not legal advice or a substitute for the advice of competent counsel. Prior results do not guarantee a similar outcome. The content reflects the personal views and opinions of the participants. No attorney-client relationship is being created by this podcast, and all rights are reserved.